Good afternoon to all of you, wherever you are. So we are resuming our free law school entrance examination, revision tutorials 2025. I presume this is a session number 10 or so, if I'm counting correctly. So we are going to do contract now. As I said, we'll be doing the revision randomly, in the sense that we don't have the luxury of time. And in terms of topics too, we are also going to be random about topics. The reason being that the examination itself is random. Why do I say it is random? Random in the sense that if we take each of the 6 examinable subjects, only one question is going to come. And there is no predetermined criteria for students regarding which particular topic is going to be examined on. So what that means is that in terms of preparation too, we have to have everything on the table because all topics have equal chance of coming. So you'll be picking and choosing as and when we want to look at a particular thing. So this afternoon, I have a question on contract, which I would like us to discuss. But before we do that question, I would like us to quickly revise what we know already regarding remedies for breach of contract. Now, remember when I used to teach this subject for many years in KNUST and Lancaster University, my approach and the approach of the teaching team was always to start with this after doing introduction to contracts. It sounds a bit odd, but it makes sense because in real life situation, when a person has a problem with contractual breach and he or she goes to a lawyer and for that matter go to court, what the person is looking for is a solution. And the solution is what we call the remedies. So those I've taught before, what I'm teaching here is just a summary form of the lecture notes we'll be using to teach you when you were in the first year. So first of all, we need to appreciate that remedy is the means by which a court enforces a right or redresses a breach of contract in this particular case. So where a contract has been breached, as we know, the remedy available will depend upon the type or the nature of term which has been broken. You notice that we have what we call a term which may be classified as a condition or a warranty or a nominate term. Those of you on my YouTube channel, Ghana Law TV, I have done full lectures, already on each of these topics. So in case you need a brush up and you don't want to maybe go and read before, but you want somebody to speak to you, just feel free. If you go to the YouTube channel, we've organized it into, we have the free law revision playlist or podcasts. And then we also have certain subjects, maybe like contracts, constitutional law, Ghana legal system, and so on and so forth. So if you go to the one on contract, for example, you will notice that there are previously recorded lectures on, let's say, terms of contract, remedies for breach of contract, and all the topics which constitute contract. So you can play them back in order to update you whatever you need. If you have a difficulty in accessing, you can just send me a message in my WhatsApp, and then if I see it, I will assist you, or you ask your friend to assist you. So if the term breach is actually a condition, then what it means is that the innocent party is entitled to treat the contract as having come to an end. That is, repudiate the contract and sue the defaulting party for appropriate remedies, be it the damages or, in some cases, some other equitable remedies, as the case may be. On the other hand, where the term breach is not a condition, then what it means is that the contract cannot be treated as having come to an end. The contract cannot be regarded as terminated or repudiated. The contract will remain in force, except that the innocent party is entitled to get compensation for the breach which has occurred, but the contract will remain in force. And where it is innominate term, also known as intermediate term. Remember the case of a Hong Kong Fair against Kawasaki, Kajan, Kazakis, where Diplock will make the point that there are certain types of obligations in the contract which you cannot classify until there has been an actual breach. So when there has been a breach, then you assess the effects or the impact of the breach on the entire contractual arrangement, the remaining obligations, and then the rights. If the breach, for example, is so significant, so substantial, that it actually makes continuation of the contract, whatever the contract is about, is really useless, then the innocent party will be able to assess remedies which are usually provided for breach of a condition. On the other hand, if the impact is not so significant, so that the impact is minimal, as really not affecting the substance of the contract, the remaining contractual obligation, and then the contract can remain as originally designed, then the innocent party will not be able to repudiate the contract. The contract will remain in force, and he will be able to assess damages or compensation for the breach which has occurred. So let's keep that in mind. The remedies for breach of contract, we can say, emanate from three main sources. The common law, like, which is damages, monetary compensation, and equity, typically specific performance and injunction. Somebody may mention, what about rectification and rescission? Well, rectification and rescission are not remedies for breach of contract. They are remedies, all right, but not for breach of contract. Rectification is where you have a prior agreement, right? Oral agreement, and subsequently it is reduced into writing. But then the written contract does not accurately reflect the prior oral agreement made, in which case you bring it to the attention of the court, and then when the court is satisfied that the agreement actually reduced into writing does not accurately reflect the agreement which had been reached by the parties before they reduce it into writing, then the court will order that that written agreement should be corrected or should be rectified in order to accord with the intentions of the parties. So in that respect, you are not providing a remedy for breach of contract. You are providing a remedy to correct an error which was made in executing the contract, as it were, by reducing the contract into writing. That is why we don't put rectification as a remedy for breach of contract. So please, don't make that mistake. Yes, rectification is an equitable remedy, but it's not an equitable remedy for breach of contract. What about rescission? Rescission is also an equitable remedy, but is not a remedy for breach of contract. Why do we say that? Now, rescission simply means to cancel, right? It simply means to cancel or to set aside. And where a contract has made and the contract is vitiated, in other words, the contract is defective. It's defective because one of the parties to the contract or both parties to the contract might have given their consent to the contract as a result of some mistake or as a result of any of the known vitiating factors, misrepresentation, duress, undue influence, and so on, or mistake. Then, when the court is satisfied, the contract cannot remain as it was understood to have been made because the contract, as it stands now, is based on a faulty premise, which is the vitiating factor. So the court will now say that the contract should be deemed as no longer being there. And sometimes, when it is set aside, what it means is that sometimes it may even operate ab initio. As far as the law is concerned, when it was thought that a contract had been made, there was no contract at all, as it were. Or, for example, if you're dealing with the unilateral mistake as to identity of the other contracting party, usually there's an element of fraud. Remember the case of the Candy and Lindsay, Ingram and Little, Lewis and Ivory, type of cases, and then a great piece shipping. So where the person who has be defrauded, as it were, by the rogue, later becomes aware of the fact that he has been a victim of fraud, he or she will now take steps in order to release himself or herself from the contractual arrangement. So he or she is avoiding the contract. So later on, when, for example, he's sued by the other party who is, as you know, like from those type of cases where a suit is brought, then he will make an argument that, well, when I became aware of the fraud, I repudiated the contract. What did I do? I did something open, or I lodged complaint with the police, or I made it overtly clear that I was not bound by this contract. So that is rescission. So that is not a remedy for breach of contract. Breach of contracts, we are talking about where the contract is properly made, somebody is supposed to perform obligation or duty, and he or she has failed in performing the obligation or the duty. And for that matter, the other party who have benefited from the performance of the obligation or the duty is entitled to look for remedy for that breach. So that is what we are concerned about this afternoon. So the remedy may be common law remedy of no damages, which is monetary compensation, or equitable remedies, which are all discretionary, like specific performance, by which you order the party, the defaulting party, to carry out exactly what he or she undertook to do. And as you will notice, when it comes to contract involving rare commodities which cannot easily be, for example, obtained, even where you have the money on the market, or what we are dealing with land, because location of land is so important. And the land at, for example, Adenta may not be the same as the land at, let's say, Dansoman. So where there's a contract for the sale of such a land and there's a breach, payment of money will not be sufficient. You rather want the same land to be given, so specific performance will be decreed. And then injunction. Injunction you are ordered to desist from a wrongdoing or to reverse a wrongdoing, as the case may be. And of course, if you look at the Sale of Goods Act, we also have statutory remedies, although they partake of the same damages and as we are talking about. And of course, Contract Act, particularly when it comes to frustrated contracts, that is a contract which cannot be performed strictly according to the original design due to certain supervening events. When we say that frustration has kicked in, yeah, so the solution is provided there. If you look at typically section 1, subsection 2 and 3 of the Contract Act of 25. So the point is remedies are not automatic. The court will exercise discretion and then depend upon the circumstances of the case. So quickly, when we say damages, what are they? As I indicated, damages are monetary compensation, right? Which are awarded for breach of a contract. The basic purpose or the aim of awarding damages is compensation. It's not punishment. So damages are never punitive. And let's be clear, when it comes to contract, right? Award of damages in contract, the point is never to punish the defaulting party, no. Because the law takes the view that in contract, both parties have negotiated, okay, and have assumed certain obligations upon themselves. So if A performs his side of the bargain, B will get that which he contracted to get. If B performs his side of the bargain, A will get that which she contracted to get under the contract. What that means is that should A fail in performing his side of the bargain, B is going to lose out, will not get what he sought to obtain under the contract. And for that matter, he will need to be put in the situation that he will have the aim if A had performed his side of the contract. And the court will award monetary compensation, no, sufficient to bring B to the position that you have been in if A had actually performed the contract. So in that respect, A in being made to pay monetary compensation is not being punished, no, at all. And that is why we said that the primary A is compensation, not what, no punishment. And the authorities like Robinson and Harman has made that point that damages seeks to restore the innocent party to the position he will have been in if the contract had been properly performed. And the aim is never to punish. So the Robinson and Harman, let's keep that in mind. Of course, Muller against the Home Finance Company Limited also followed the philosophy or the rationale for awarding damages articulated in Robinson and Harman in the case of Muller against the Home Finance. And that was a contract for the sale of a house. And the court took the view that the plaintiff was not only entitled to open market value of the house, but also lost rent since purchase. In other words, if the contract had been carried out as made, when the person purchased it, he or she could, for example, let it, and that will have brought some money to him. So if there had been like a breach, for example, in honoring the sale agreement, just giving money, which ought to have been paid for that house, if it was just being sold in the open market, would not suffice. But you should go back. If you had made the payment at the time payment was supposed to have been made, what other things would the purchaser have obtained? So that was the focus. Now, in terms of damages, various types based upon the circumstances. So we have what you call the expectation damages. That is to say that in awarding the monetary compensation, we are looking at the expected benefits of the contract. If the contract had been carried out as agreed upon, what will you have obtained under the contract? So in awarding monetary compensation, we are going to give you a quantum, which will be enough to give you what you have obtained if the other party had performed the contract. So maybe like lost profits, for example. If the contract be performed and you have, for example, made certain known or sustainable profits, that will be awarded. Or difference in value of goods. So if the contract have been performed and you have had a certain weight of a good, but now you are not going to have that, we will award the compensation to reflect that. Then we also have what they call the reliance damages. So reliance damages covers wasted expenditure incurred in reliance on the contract. And how is it? So typically, if you look at like the case of the Angular Television against Reed, for example, there was a contract for series to be produced, and those in charge of the production had actually made certain expenses trying to get the show produced. But in the course of time, the TV, the Angular Television, which was supposed to, for example, show the series, had a change of mind and then they canceled it. Then when they were sued, in terms of the damages that they had to pay, of course, they could not calculate what benefit that they have made had the shown be actually be aired and all that. So the court said that they could recover expenditure which they had incurred in attempting to produce the show. So the expenditure that could be ascertained, okay? So reliance damages is like the expenses that you have incurred in trying to carry out the contract before it was breached by the other party. So where it is not, practical for us to determine how much benefit you have made if the contract have been, performed by the other side, we can let you recover compensation for how much you have actually lost in an attempt to comply with your side of the contract, which has now been breached by the other party. So that is the reliance damage. An Angular Television against Reed is a good illustration. And then we also have what they call the nominal damages, and it is awarded where a legal right is infringed, but no substantial loss occurs. So the point about the common law, and particularly contract, is that once you have proven that there has been a breach of the contract, that the party has not carried out an obligation under the contract as actually agreed upon, the law takes the view that the other party, the innocent party, should be given some relief or some compensation. But it may well be that the innocent party has not suffered any loss, has not suffered any disadvantage, despite the fact that one party has actually not carried out the contract as made. So therefore, just to give effect to the principle that when there has been a breach, damages or compensation should be awarded, something will be awarded. So nominal damages, as the name suggests, nominal means in name, just symbolic. A token compensation will be awarded. So Maserati against Williams speaks to that. Then, of course, we also have what they call the speculative damages, and that is granted where loss is uncertain, but the court makes an estimate. So where there has been a breach of contract, but there's no certainty regarding how much has been lost, then the court will make a reasonable estimate regarding how much compensation should be awarded. Then we also have this aspect of damages, which has come up in contract, what we call the non-pecuniary damages. That is compensation for non-financial loss, okay, such as loss of amenity, disappointment, or distress. So loss of amenity, for example, I like my favorite case of Rosary Electronics against Fawcett. In Rosary Electronics against Fawcett, Mr. Fawcett actually engaged the company to construct, uh, you know, to construct, a swimming pool of a certain specifications for him. They did the pool all right. However, they did not follow strictly the agreed specification. So there was definitely a breach. Nevertheless, when the pool constructed is examined, it was found that in terms of functionality, it was very functional. You could dive in the pool like in any like, so there was no use or there was no function which the pool could not be put. But the court took the view that insofar as the contract had been made for a pool of certain specification or dimensions to be made, and those who constructed it having not honored the exact dimension or construction, the person who engaged them has lost a certain satisfaction. And that satisfaction is intrinsic, right? It's not something that is not physical. It's just like, I give you a typical example. Let's say that if I tell you that I want you to, let's say I'm buying a vehicle, okay? I need a Mercedes-Benz E-Class. I'm buying a second-hand one, but I don't want one which has done more than 20,000, no, 20,000, let's say, kilometers, okay? And you get a Mercedes-Benz E-Class, which has done 20,000, 100, kilometers. And what you have brought in terms of performance and everything is just the same as Mercedes-Benz E-Class, which has done 20,000 kilometers. Nevertheless, according to the authority of Rosary Electronics against Fawcett, there is something I have lost, a certain satisfaction which I will have personally derived by having a vehicle which has only done 20,000 kilometers and no more than that. So that was the situation with Mr. Fawcett. And the court was prepared to award damages or compensation for loss of amenity. The same thing applies to maybe disappointment or distress. Like Jarvis against the Swantos, somebody entered in the contract with the holiday company. You bought a package, and how the holiday destination, the things there, and the enjoyment have been explained in the package. When he got there, it was completely less than that, and the court held that he was entitled to be compensated for the disappointment. So disappointment is non-pecuniary, non-pecuniary in the sense that it's non-monetary, but the court was prepared to award the damages in that respect. So let's keep that in mind. Again, you take our own case of Justin Smith against KLM. Interesting case. And then somebody said he was traveling abroad, and in Belgium or so, to go and sign a certain contract. So there was a development. So KLM delayed him and could not fly him on the agreed date. And he sued the airline for damages. That's compensation for so many things, including the air ticket he had paid, including the contract or the business opportunity that he was going to sign in his destination. But the court actually uh, denied him award of compensation for the speculative lost business profit, because the court said that if you had even reached there was no automatic assurance that the business deals we were going to make was actually going to make the profit that you had actually sought to recover compensation for. So that was denied. But then the court awarded compensation for inconvenience, which he has suffered, having to sleep in a hotel, having to do certain things that he would not have done if he had been flown on the day that he had actually been told he would be flying per the ticket that he originally acquired. So these are some of the types of compensation or damages which may be awarded. So let us keep that in mind. Another point which we need to revise quickly, as I said, what I'm doing is just a abridged lecture. The full lecture is on the Ghana Law TV. We have a full lectures on remedies for breach of contract. You can just go and play it back if you want. But it's just like a quick revision so that we can discuss one question at the bottom of it before we end this session. Then we come back later on. So one point to remember in talking about damages is the principle or the doctrine of remoteness of damages. Okay, remoteness of damages. So when we talk about remoteness of damages, we are talking about the fact that the court would allow damages or compensation to be recovered for damage. Damage here without the S. So damage here refers to loss or injury. The court will allow damages. So when the S is added, damages, we are talking about monetary compensation. When S is not added, we are talking about the loss suffered or the injury. Okay. So the court will allow damages, that is monetary compensation, to be awarded for damage here as meaning injury or loss, okay, which are not too remote, which are not too unconnected, if you like, to the breach complained of. In other words, the court will need to be satisfied that there is a nexus, there is proximity, okay, between the loss, the damage or injury, which you are seeking to recover monetary compensation, you are seeking to recover damages. And the approach which Baron Addison articulated in the well-known case of Hadley and Basendel, which have been clarified and built upon in cases like Henry II, Victoria Landry, and Newman, are quite instructive. So the position of the law with respect to remoteness of damages is basically that you can recover compensation or losses, okay, which arise naturally from the breach. So losses which are direct from the breach. In other words, had it not been for the breach of the contract, those losses would not have been suffered. So if they arise directly from the breach, then they are recoverable. So that is the so-called the first limb of the rule in Hadley and Basendel, okay? And then the second one has to do with losses which should be recoverable if they were within contemplation of the parties. In other words, if at the time of making the contract, both parties had the benefit of certain information, okay, which information were to the effect that if the contract is not carried out as made, a party was going to suffer a certain disadvantage, a certain loss, then such losses will be recoverable, despite the fact that they are not emanating, if you like, directly from the breach of the contract. But because of the information, because of the knowledge which the parties had at the time of making the contract, the court will say that uh, they he could have foreseen, or he could have contemplated, he could have known ahead of time that if he did not carry out the contract, the other party was going to suffer those consequences. Meaning that if he had not been given that information, okay, and a breach of contract occurred, he will not have been in a position to appreciate those other losses which the other party will have suffered, apart from losses which are considered as arising naturally in ordinary course of events from the breach of the contract. So that is the rule in Hadley and Bassender. And that is why, if you look at the test writers, including my own teacher, Professor Dona Hammond, the point will be made that the first limb, we can call it like the general damages, okay? And then the second limb, we can call them the special damages. So the general damages are those losses which arise directly from the breach of the contract, naturally from the breach of the contract. And then the special damages are those which are supposed to be within the reasonable contemplation of the parties. And you know the facts of Hadley and Basenberg and the Victoria Landry and her result, not belabor the point. And of course, in our own Frafra against Boache and so many other cases, including the data case, the Supreme Court has actually followed these principles, and almost every contract case which has come before our courts has been followed. Just give me a minute, okay? Okay, my apologies. I'm back. Yeah, so it is important for us to know which losses, which damage or injuries when a breach of contract has occurred, the court will allow compensation to be recovered for. So that is very important. And if you get any problem-based question, and for example, there's something to do like the breach of contract and the need for damages or compensation to be paid, you must ask yourself, this particular thing, is it one of the general damages as arising naturally from the breach, or it is one of the special damages, which will depend upon the type of information, right, or knowledge, which was actually given at the time that the contract was made, or what we call the actual knowledge and imputed knowledge, as in Victoria Land against Newman, Lord Justice Asquith will put it. Yes, for imputed knowledge, every reasonable human being is assumed to have appreciation of certain reasonable things within the particular circumstances. So that one means that and that is useful when we are dealing with the first limb of the rule. But then the actual knowledge, that is what we call like the special knowledge. If you've actually been given a certain knowledge or information that, for example, as we saw in the Victoria Laundry, that we have like a special contract to deliver on. So if you don't come and fix the laundry boiler according to the agreed timeline, we will not be in a position to actually deliver on those contracts. Then because we have told you this ahead of time, if you are not able to meet the contractual deadline, you should know that we too will not be able to meet our contractual deadline, and whatever we're going to gain from that, we'll lose it. And you should be made to compensate us for losing that. So that is the special damages. Then we also have the principle of mitigation of loss or mitigation of damages. And it's simply to the effect that when a breach of contract has occurred, the innocent party who is entitled to sue the defaulting party for compensation is required by law to take reasonable steps in order to reduce or minimize losses which emanate from the breach of contract. So, for example, if there are certain things that you could do in order to minimize the effects of the breach of the contract on your rights under the contract, then the law requires you to do that, so long as it's not burdensome, right? And if you don't do that, it could reduce the quantum of damages or compensation which the court will award to you. So you are not supposed to say, fold your hands and say that, okay, if the contract has been breached, you are not going to do anything at all, particularly so if what you could have done to minimize your loss was something, for example, not really cumbersome, something reasonable, then as we saw in the case of the Hapsen plastics again Wintan, the court will have regard to your unreasonable inaction to reduce the amount of compensation which will be paid to you, or the quantum of damage which will be awarded to you. But as I said, it doesn't have to be something unreasonable. It has to be reasonable. And the same vein, if you look at our law, that is the Sale of Goods Act, right? Sale of Goods Act, for example, we have additional provisions on award of damages, particularly when it comes to contract for sale of goods. And as you know, contract for sale of goods applicable to sale of movables, okay, movables, as opposed to movables. So assuming if the contract is for a sale of land or interest in land, certainly sale of goods act is not applicable. So you should remember that. But where the subject matter of the contract is not about real estate or it's not about immovable, then the sale of goods act is applicable because the sale of goods act relates to contract for sale of movables. So where that is the case, for example, there's been a breach, we have a certain provision which gives us additional guide regarding how we determine the damages. But the provisions of the Sale of Goods Act are more applicable in dealing with another dimension of damage, what we call the measure of damages. So measure of damages, that's a computation of the damages. What we just finished talking about the remoteness of damages, okay? The remoteness of damages, we are trying to determine what type of losses which a person claimed to have suffered following a breach of contract can be compensated for by award of damages. Not all losses, not all heads of losses. So what type of losses, what heads of losses will be permitted to be compensated for when there has been a breach of contract? That is where the principle of remoteness of damages come in. So hardly again Bassendel and this line of jurisprudence, okay? And following that, we also have the qualification of mitigation of damages, that when the breach has occurred, if you can do something which is not too cumbersome but reasonable for you to minimize the quantum of damage, then you are supposed to do that. Otherwise, the court will have regard to your unreasonable action in order to reduce the amount of compensation to be awarded to you. So that is about remoteness. Now, after determining the type of losses which can be compensated for by way of damages, the next question is how much money is going to be awarded for this loss which we have determined is recoverable following the breach of the contract. So the quantum, so the measure of damages or the assessment, the measure of damages or the assessment deals with the quantification of the losses in monetary terms, how we reduce or we translate the losses which the court has determined according to the principles of remoteness of damages are compensable, meaning that you can compensate by award of damages. How much money, how much damages are going to be awarded? So that is what the measure of damages or the assessment of damages need to do. And that is where provisions of the Sale of Goods at 137 become very useful. So for example, Section 53 will tell us that the buyer may claim damages for non-delivery. So how do you measure it? Section 54 says that the difference between the market price and the contract price. So market price refers to how much the item is being sold now, okay? And the contract price refers to when the contract was made, what was the price which the buyer was supposed to pay to the seller or the vendor? So the court will strike the difference between the agreed price, that is the contract price, and the market price. So for example, if the contract price was 1,000 Ghana cedis, okay, and then the market price is 1,200 Ghana cedis, we deduct the contract price from the market price, and 200 cedis is the difference. So 200 Ghana cedis will be awarded as the damages, if you like, because if the contract price had been paid, or if the item had been delivered, depending upon whatever happened, it would have been worth 1,000 Ghana cedis, but because of the delay or the default, now the same thing is costing 1,200 Ghana cedis. Of course, if you do that, let's assume that the market price is also 1,000. The contract price is 1,000. So what it means is that no loss has been suffered. In that case, nominal damages will be awarded. The court will award a paltry sum, some small amount of money, and as I said, the purpose of awarding the small amount of money as a nominal damages, it just vindicates the principle that whenever there's a breach of contract, damages should be what? Should be awarded, regardless of how insignificant it may be. Then we also have specific, equitable remedies. As I indicated, two are important when we're dealing with remedies for breach of contract: specific performance and then injunction. So we know specific performance is a decree of in a court of equity compelling actual performance of contractual obligation. So being equitable remedy, it is discretionary. Discretionary means that the court has a lot of latitude based upon circumstances before it to grant it or not to grant it. And in that regard, all the maxims of equity that we know are also applicable mutatis mutandis. So, for example, he who comes to equity must come with clean hands. If you are looking for specific performance, okay, and if the evidence, for example, show that the other party wanted to perform, but you prevented him from performing, then you cannot approbate and reprobate. As somebody will say, you cannot eat your cake and have it back, as it were. The person was endeavoring to perform his contractual obligation, but you impeded him from doing so, then the law will not allow you to now complain and say that the person should be compelled by the court of equity to carry out his obligation because you yourself, you haven't done equity. The clean hands doctrine has caught you. You have prevented him. So if you prevent someone from carrying out his obligation, how can you, as a court, compel him to perform? And of course, all the other maxims of equity are applicable. You know them, so I'll not belabor the point. Another thing to note about specific performance is that it is granted only when damages are inadequate. Where damages are adequate, specific performance will not be granted. In other words, where there has been a breach and the situation is such that monetary compensation would do justice to the innocent party, then no specific performance will be decreed. On the other hand, where monetary compensation will not be enough, then specific performance will be granted. So when it comes to contract for sale of goods or unique property or rare commodities, for example, it will be granted. So it's very common there. But then when it comes to ordinary goods, which are really common, specific performance will not be granted. But for example, maybe antiques or art or scarce commodities, you get specific performance being awarded, as it were. Then it will also not be granted where damages are adequate, as the case of a Redco against Sapon. And then when it comes to contract for personal services, that's employment contract, okay? Specific performance will also not be awarded for obvious reasons. So, for example, if an artist are signed up to go and perform at a show and he or she decides not to go, the court will not decrease specific performance because, for obvious reason, you cannot force a person to perform against it, so he will not even perform at all. Then, it will also not be granted where it will require constant supervision, okay? As happened in the cooperative insurance against the agile source. And as I have indicated, specific performance is subject to the equitable principles. So clean hands, there should be no undue hardship, there should be no undue delay. They're all applicable. And of course, the principle of mutuality. the remedy must be available to both sides. So that is to say that if a minor, for example, cannot get specific performance decreed against him, then certainly it will also not be decreed in his favor. Now, when it comes to, let's say, sale of goods, you know that we have what we call the specific goods, and then ascertained goods as well as unascertained goods. So for specific goods from the sale of goods laws, as you remember, goods which have been identified and agreed upon before the sale. Now, where there has been a breach, the court would order that specific performance should be decreed so that the same item will have to be provided as it were. There are a lot of case law in that respect. Then we also have injunction. Injunction, as you know, is also an equitable remedy by which a person is ordered to refrain from a wrongdoing, to reverse a wrongdoing. So, for example, where a person evinces an intention not to carry out a contractual obligation, prohibitory injunction can actually be granted to prevent the person from his decision to breach the contract when it is time for him to perform. So there are certain types of, so for example, remember what we call the anticipatory breach, okay? Anticipatory breach is where maybe we discuss a discharge of a contract and then we talk about anticipatory breach. But anticipatory breach, from the word anticipation, expected. So you have a duty or obligation to carry out under a contract. But before the scheduled date or time for performance, okay, you indicate your intention not to carry out the contract on the agreed date and time. Now that is anticipatory breach. You have made your intention known to the other party that come that date or time, you will not perform. It is anticipated. It's not an actual breach because it's not yet ripe. The time is not yet ripe for performance to be made. So you haven't actually breached, but you have evinced clear, unequivocal intention that you will not perform. So, for example, where that is the case, the other party, depending upon what is at stake, if he is desperate for you to carry out the contract, he may go to court, right, and let the court prohibit you by injunction and say that you are restrained from carrying out your intention not to carry out the contractual obligation. So that is a prohibitory injunction. Or sometimes we have like a negative covenant, and we can also use that to prevent you from breaching it. For example, when it comes to what they call the contract in restraint of trade, okay? Contract in restraint of trade, typically in employment contracts, where you have you are employed and your employer in employment contract will insert a clause to the effect that should you stop working with the employer, you are not going to work with, let's say, rival companies or entities. So that is a contract in restraint of trade and a personal contract of employment. That's happened in the Warner Brothers against Nelson. The actress in that case, for example, was restrained from working with the rivals, but not forced into personal service. So meaning that the court will not grant injunction for you to necessarily perform for, let's say, under your employment contract, but prohibitory injunction can be issued against you to compel you to comply with your covenant not to work for rival companies or not to compete, as the case may be. We also have what we call the restitutionary remedies, and by restitutionary remedies, we are talking about situation of unjust enrichment. We have situations in contract, okay, where there's a case of something having gone wrong in a contractual scenario. However, because of certain technical challenges, we do not have a contract properly so-called, so as to say that the innocent party can assess remedies which are meant for breach of contract. That notwithstanding, someone has lost money or someone has given value to the other party and has not had anything in return. And this person cannot assess remedies for breach of contract because what you have does not actually meet the full criteria of enforceable contract. So what do? Should the party who has received something under the contract be allowed to keep it when the other party who has given something under the contract has not had any benefit whatsoever? So that one will give rise to what we call a situation of unjust enrichment, where someone is enriching himself unjustly in the sense that he's not done anything to deserve it. So where that is the case, equity will intervene to prevent unjust enrichment. So we have something called a money hard and receive, okay? So like typically, for example, let's say that when it comes to, and the same principle, which was or what you call the quantum merit, and also when it comes to adjustment of right in the frustrated contract. So let's suppose that someone is supposed to perform obligation under the contract. He's not carried out the full obligation, but he's carried out the part of it. And if you say that because he's not carried out the full obligation, he should not be given any payment whatsoever. Now, some obligation have been carried out, so the other contracting party has received something under the contract. So, if you are to insist that because he's not carried out strictly what the contract says he should perform, he's not going to be given any thing, then you are going to have a situation of what? Unjust enrichment. And that was one of the problems associated with the so-called precision rule of what? Of performance, when we are dealing with the disabled performance. And equities came in and said that no, that is unfair. Where a person has carried out aspect of the obligation of the contract, another party has benefited from it. The mere fact that the defaulting party is not really carried out in full what is expected of him should not be a reason for him not to get anything and for the other party just to hold on to what he has received when he in turn has not done anything. So the court will come in and say that we are going to allow you to recover payment for whatever your performance is worth. So that is the quantum merit, or sometimes money hard and received. Particularly so, let's suppose that you have a contract which has been frustrated. So if you look at section 1, subsection 2 and 3, contract have become frustrated, but before the frustration occurred, some payments have been made or certain expenses have been incurred. Then the court can have regard to it and say that no money had and received, or sometimes you even come to, let's say, the so-called the illegal contracts. Some contracts which are illegal, and if you are to come on the basis of the strict terms of the contract, you will be faced with illegality if you cannot bring yourself within any of the exceptions regarding when you can recover money transferred under illegal contract, then you're going to be in trouble. So to guard against that, you'll be allowed to have some payment on basis of a money had and received, some discretionary claim. So if you remember the Justice Datiba's approach in the case of Country and City Waste Limited against Accra Metropolitan Assembly, it develops that idea further. Another point which we should note is about extension of remedies. Extension of remedies. In other words, in law, there's this principle that there's a public policy that litigation should come to an end. If you have a claim against someone, you don't have to go to sleep. You must be quite timeous about pursuing a remedy. And that is why we have a law called the Limitation of Actions, okay? Or Limitation Decree, now called the Limitation of Actions Act, or Limitations Act. It prescribes a time period within which cases should be brought for certain type of matters. And if you don't bring it, then you are said to have your case statute bad or out of time. So, simple contract, for example, you have 6 years. So if there's a breach of contract and you allow more than 6 years to elapse before you want to come to court, your action will be considered a statute bad. So let us keep that in mind. Of course, when it comes to land, it's 12 years, as you know from your land law. But with respect to equitable remedies like specific performance and injunction, it's not subject to limitation, but the courts will apply time bars by analogy where the justice of the case demands that. So this is just a quick brush up of what you are supposed to know with respect to remedies for breach of contract. I'm going to put a question there and I will allow you 3 minutes and then I'll open the line for you to tell me the issues which need to be identified, okay? And the question is this. Let you get a full listen. Good. Mr. Boateng is a retired civil servant, the resident of Kumasi in the Ashanti region in April 2021. Mr. Boateng, actually, this is one of my past questions to some of my students. Mr. Boateng tested positive to COVID-19 and was admitted at a Konfano Teaching Hospital for treatment. While on admission, Mr. Boateng saw a TV commercial of a supposed drug by Dr. Nyaho, a herbalist at One Touch Herbal Clinic for the treatment of COVID-19. A TV commercial was done by Dr. Nyaho himself, in which he unambiguously stated that anyone who uses the said drug for 2 weeks according to his prescription and is not cured of COVID-19 shall be given an amount of 1,000 Ghana cedis as compensation. Dr. Nyaho further indicates that an amount of 10,000 Ghana cedis is deposited in the GCB account of One Touch Herbal Clinic for the purpose of meeting any claims by any client who is not cured of COVID-19 after using the herbal drug in accordance with prescription. Mr. Boateng immediately sent his son, Yamiche, to purchase the said drug for him while still on admission at Konfanochi Teaching Hospital. Upon procuring the drug, Mr. Boateng diligently and religiously used it in accordance with Dr. Nyaho's prescription, but still tested positive to COVID-19 after the 2 weeks period. Subsequently, in June 2021, Mr. Boateng visited One Touch Herbal Clinic to claim compensation of the 1,000 Ghana cedis as indicated in the TV commercial by Dr. Nyaho. But to his surprise, he was told that there's no such compensation to claim. Mr. Boateng is irked by this revelation and has approached you for advice. Advise Mr. Boateng. Yeah, so that is the question. I think that if you go to, I think I have pasted the question. Let me check. I think I've pasted it on those of you on the YouTube. Let me see. Uh, yeah, I tell you, if you go to the YouTube live, okay, I've pasted the question there. So if you want to see like in full, because of the screen sharing, we're not able to let the full this thing appear. If you go to the YouTube, if you go to the YouTube live, so I'm giving you just 2, 3 minutes, and you tell me uh, what you'll be able to put down. Let's see if I can put it on the WhatsApp platform too. Let me see. Yeah, I think I've put the question on the WhatsApp platform too. Okay, so a minute and then you talk to me how you go about it. Just one person at a time. Okay, let's go. Yes.
Look, I would like to just look at some of how I looked at the question.
Okay.
So when you look at the whole question, it's a unilateral offer which is made in a general form.
Okay.
And it's been specific. He has made a specific promise. If anyone uses the product by following the specifications, and within 2 weeks, the person is not cured, the person should take or be compensated with 1,000 cedis. That's so specific. So I want to look at whether or not that promise is an offer. Again, you realize that Mr. Boateng bought the drug and used it according to specifications. So I also want to look at whether or not that performance amounts to acceptance of the general offer given in unilateral form. And so I will look at a case of Khalil versus Carbolic Smoke Ball.
Okay.
In that regard. And then, so if he has done that, I've also looked at whether he can actually get the court to force Dr. Nyaho to perform his part as well. So whether or not he can seek remedy under specific performance. So this is how I've looked at the issues and then begin to develop them.
Okay. 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 I mean, that's a noble start. Yes. Any other?
Yes, Doc. Good afternoon. So, just to add to the colleague who spoke earlier, clearly the area of law is looking at breach of contractual obligation or breach of contract, and the legal issues that may be arising for determination will be whether or not there was a valid contract between Mr. Boateng and Dr. Nyaho's One Touch Herbal Clinic. And also, there will be the issue of whether or not Mr. Boateng could claim damages for breach of contract. I so submit, sir.
Okay. Thank you. Any other? Yes, I'm sure you've all looked at it. Let's hear you. You have to let it be interactive, not just all the time. You know the thing already. All we are doing now, we are just revising.
Hello.
Yes.
Yes. Respectfully, I would like to look at it in the area of offer and acceptance, specifically unilateral offer. And I think the narration was very precise and the offer was unambiguous. So whether or not the herbalist, that's Dr. Nyao, gave whether or not the offer made to the whole world, that's unilateral offer, was a valid one.
Okay.
And in that particular case, you can look at NTAC versus entry.
Okay.
So when you're developing the rules, when you are giving the rules, you can develop from NTAC versus entry. Because offer, as we do know, is a statement, unambiguous one, and it is precise and it's exact. So that's what I look at. The second issue I would like to look at is whether or not in the narration, what's the name, Mr. Nyameche's son, whether or not he can successfully sue the herbalist, that's Dr. Nyao.
Okay.
He can successfully sue Dr. Nyao and claim the compensation of the 1,000 Ghana cedis. So I would like to look at these two issues. And when I'm developing it, I think in my rules, I also would like to talk about acceptance, but I don't think that I would like to isolate acceptance as a clear issue to be raised.
Okay.
Thank you.
All right, thank you. Yes, any female voice? You have 2 male voices or 3? Yes.
Say, good
Yes.
afternoon, sir.
Good afternoon.
For me, I would also look at it in the angle. So in this angle, in raising my issues, I would want to ascertain whether or not there was a binding contract between Mr. Boateng and Nyaho Clinic. And then also as to whether there was a breach of contract for which Mr. Boateng could have a successful claim against Nyaho Clinic. So in determining the first issue, I would like to look at the elements of a valid contract to determine whether or not indeed there was a binding contract between the parties. So I would like to explore the angle of an offer, whether or not the offer made by Nyaho Clinic was a valid offer or maybe just an invitation to treat. I'll look at acceptance, whether the acceptance by Mr. Boateng constitutes a clear acceptance. I'll look at consideration as to the actions of Mr. Boateng paying the 1,000 Ghana cedis and also using the product as prescribed diligently. Then I will determine whether there was indeed an intention to create legal relations. So having said that, then I'll come to the conclusion as to whether there was a binding contract between the parties. And then for the breach and in respect of the successful claim for compensation, I would look at the area of the compensation. I'll look at the area of general damages as we have discussed. And then the case in point I would like to use would be Khalil versus Carbolic Smoke Ball. Thank you very much, sir.
Right, thank you. Any other? Yeah, so as I said, this is something I've used in exams some years ago, just around the COVID time. It's a very straightforward question, and I think almost all of you got it. It's really about this unilateral contract. So we are interested in finding out whether the TV advertisement, for example, was an offer, not a mere invitation word to treat. And whether the acceptance could occur by performance without prior notification, as we know those things. Of course, question may arise whether there was consideration intended to create legal violations, just as we saw. Remember the case of Kyle and Kabul small body issue, which came up over there. Yeah, so these are some of the issues which need to be considered. Was the advertisement a binding offer? You mentioned the NTAC versus entry, which is good. And then acceptance by and performance by Mr. Boateng. Of course, with issues of the issue of consideration, that is not a big deal, as we know that our own law of 25 has even abolished or substantially modified consideration, so that it's not a big deal. But that notwithstanding, purchasing and using the drug will have also be like a sufficient consideration. And intention to create a legal relation, for example, we look at the fact that, just as remember, I mean, this question is actually, we adapted the case of Kyle against Kabalis Mugbo. So as we are reading it, those who are familiar with it, it will be somehow quite something that you've seen before, that they had deposited the amount of money. And if you look at the reasoning of the court in Kyle and Kabal Smoke Ball, we're told that the fact that the company said they had deposited £1,000 or so at a bank in London at a specific location and all that, all signified a serious intention. So there was definitely intention to create legal relation. So these are some of the issues which will have to be. I think there was somebody raised an issue about breach of contract, isn't it? The first person, was it the second person?
The second person, my lord.
So Mr. Mensah, so develop that point for us. Yeah, I mean, you are right. Develop it for us.
So, my lord, coming from the Kali versus Carbolic Smoke Ball, the general rule is that where a general offer is made to the general public, performance is basically about the the consideration is by performing the act that was required. In this case, Mr. Boateng buying the medicine and following from the facts, following the laid down directive or the guidance for taking the medication will amount to acceptance and performance by performance of the contract. And also from the fact we were told that Dr. Nyaho's herbal clinic said they have an amount of, they've deposited their money of 10,000 cedis in the bank account. So failure to give him the money for the medication not working will amount to a breach of contract.
Okay, all right, thank you. Yeah, so I mean, that's so far so good. So I mean, certainly. So in terms of the enforceability and remedies, Mr. Boateng carried out what was expected. So we had like a binding unilateral contract and was entitled to the 1,000 cedis. So definitely we'll get the remedy of that amount. No doubt about that. But what about possible defenses by Dr. Nyaho? Can he argue lack of genuine intention, that may probably not avail him. Or could he argue that Mr. Boateng did not comply? As we can see from the facts, the evidence showed that Mr. Boateng complied as directed in the advert. Can we say there was a contractual uncertainty? Certainly no. The advert was quite clear. So when you've done all the analysis and discussion, the conclusion that Mr. Boateng has a good case and you should consider legal action for breach of contract and enforcement of the unilateral promise, of course, by way of damages or specific performance, the case may be. But what I am interested in you paying attention to is to be structured in your approach. Raise your issues. If you want to add area of law, that is fine. If you don't want to add area of law and you want to just raise your issue, that is also fine. And then take issue one after the other. And under each issue, state the law, that is the principles or propositions of law, together with the corresponding cases or authorities from which those principles have been propounded. And then when you are done, under the particular issue, which you have stated the law and the authorities, you go to the application. You say like in the instant case, then you start doing your analysis and application. Okay, as to how that principle is met or is not met based upon the facts as you have. You repeat that for all the issues, and then when you finish, you draw your big conclusion. So that is how you should go about it. There is I think one recording we did some time ago on how to solve a problem-based question. Just in case you have forgotten, go to the channel and look for those how to use effectively use the IRAC and so on, and listen and be guided. Any other question before I end this session? Okay, in absence of question, we come your way with another session in the course of time, hopefully before the day ends.